This is the House Judiciary Committee. It's Monday, the 10th of April. This is a voting session. We have some concurrences. We need to do these. House Bill 226 concurs with the Senate amendments. This is a person in a position of authority bill. It changes Delegate Love's bill to be in the same posture as Holden's bill. Motion to concur. Is there a second? All right. Any discussion? All in favor, raise your hands. We already moved his bill. Anybody opposed? All right. Motion to concur is adopted on House Bill 226. House Bill 758. This is the bill on sexual assault collection kits. Delegate Bartlett's bill is being we're concurring with the Senate amendments in that bill. So there's a motion to concur. Is there a second? Motion is a second. Delegate Bartlett, I don't believe you're fine with the Senate amendments. All in favor, raise your hands. Anybody opposed? Seeing Delegate Erican and Delegate Graber, we're just stretching. Okay. The motion to concur is adopted. House Bill 297, again, Delegate Bartlett's bill. This is safe harbor. This is concurring with the Senate amendments on safe harbor. She's okay. There's a motion to concur. Is there a second? All right. All in favor? Discussion? Anyone? No. All in favor of the motion to concur, please raise your hands. Anyone opposed? And seeing none, that motion to concur is adopted. Anyone I have left in that one? So we're going to talk about. We're going to do Senate Bill 505. There are amendments. The amendments would do the following. The amendments would add language from the Vice Chair's interlock bill, or the former Vice Chair, now the Chair of Ways and Means is interlock bill. That is, what page is an interesting question. So what it does is it says that if you have been if you've received a PBJ for either the A or the B violation, which is driving under the influence of alcohol or driving while impaired by alcohol, that you would be required to enter into the interlock program. For the first time you enter into the interlock program, it is a 6-month involvement in the program. The second time is a year. The third time is 3 years. It effectively would make law that if you ever received either a PBJ or a conviction for DUI, that you would be required to do the interlock for some point in time. It also does the following. It changes the way that the bill came. Well, let me do the following. What it would say is it would also, for the first time, allow for the expungement of either a 21902A, again, driving under the influence of alcohol, or driving while impaired by alcohol, a 21902B. It would allow for an expungement after 15 years, and the person would have to, consistent with what the state's attorney had mentioned a few moments ago, the person would have to have been crime-free during that 15-year period. It would require that, and then they could get that expunged. There's a conversation about shielding that in this context doesn't work because there's a driving record involved, and you cannot shield a driving record, because if you shield a driving record, we fall out of compliance with other states and our requirements to act with other states with regard to the sharing of information regarding these and other traffic offenses. You are allowed to do expungements, however, and many other states do allow the expungements, and many of them do them with a significant period of time. That is effectively what the bill would do. And with that, I will go to Delegate. There's a motion for the amendment and a second. All right. So we'll go to Delegate Erican and then Delegate Grammer.
Thank you, Mr. Chair. So obviously this is kind of unconventional to have a hearing today and then to have a gutted bill. I'm still looking through it, trying to find where the interlock piece is. I think because these pieces have been combined like this, obviously I'm a big supporter of the interlock piece of it, and I'm not a big supporter of expungements on their face. So I would love to sort of know exactly where to look to find. Okay. Okay, so. Okay.
It takes the language from the vice chair's bill and moves it over, and it requires the interlock for people who get PBJs for the A or the B.
Okay.
Interlock doesn't work well for driving under the influence of drugs because the technology doesn't work in the same way.
Yeah, obviously, yeah. Okay, yeah, I'm a little uncomfortable with how this is moving, and this is like a basically brand new bill that we're getting at 11:30 on Sine Die. So I'm sure others have comments, but that's just my gut reaction.
I will say that it's consistent with the bill as it was introduced before the committee, and was consistent with the arguments certainly that came before the committee. Delegate Grammer.
Mr. Chair, there was a portion of the bill and the discussion in the hearing where we talked about potential changes from alcohol and excluding the other drugs. Can you talk a little bit about that?
So this only applies to 21902A and B. C is driving under the influence of drugs or a combination of drugs and alcohol. D is driving under the influence of a controlled dangerous substance like PCP or cocaine or something like that.
So we've limited the applicability to alcohol.
A's and B's to driving while impaired and driving under the influence. You would be able to get those expunged. They are the more common. Unfortunately, they are the more common, but in any case, those would be the ones you'd be able to get expunged, but those are also now the ones, they also would be the only ones that you would be able to get, they would be the ones you get required the interlock to do because they don't work for the C's and D's anyway.
Okay. You also commented on the technical non-feasibility of using shielding due to requirements to share information from other states. Can you, for one more time, explain that to us, please?
We are part of an interstate compact with, I think, 43 other states that requires us to provide information on on the violations that people have. Other states do have expungements, and they do allow for those expungements, but they don't have a mechanism it would not be possible to shield, as I read it, the information regarding a DUI from another state under the compact. And so for that reason, that's why it goes in the direction of an expungement, and it goes in the direction of an expungement after 15 years. It's seeking to balance this, and part of that balance is, again, as State Attorney Schellenberger was mentioning a moment ago, it reflects that they're going to have to keep their record clean for 15 years in order to get that expungement. It is onerous, but having said that, this is the first time that we have ever done anything like this. And so if we're going to do it, then we're going to add to the interlocks on the one side, and we're going to make it stringent on the other side to say, you need to do what you need to do to stay on the right side.
Okay. Let me just make sure I understand what I'm hearing. So if you were to shield the record, it would technically not be available to the other states in which we have a compact with. So that's why we can't technically do that.
We want to avoid that.
So, but with an expungement, it just obliterates the record, which would not be in...
But they allow for that after a period of time. It's a quirk that I'm finding really interesting as I've tried to find, that it's okay to expunge it down the road, but at the same time, shielding it, we know the conviction is there, but we're not telling you about it versus now the conviction is no longer there, so now we don't have to share the information with you.
Very interesting.
So, it's wow.
All right, thank you, Mr. Chair.
We'll now go into a discussion on the rule against perpetuities. All right, no, we're not doing that. No. Delegate Phillips, then Valentine.
Mr. Chair, you practice in this area as a prosecutor. Normally, if a person is charged with a DUI, they frequently result in a PBJ. Is that a fair statement?
It depends.
A first time.
So if it's a first-time DUI, and it's not to say that it doesn't happen where people get PBJs after they have hurt or killed or done severe damage to property. There have been some of those cases, but in my experience, those have been limited. And I'm sensitive to the people in the audience who have gone through terrible tragedies and are part of the reason that we're here today. And I'm sensitive to what you have been through. I don't mean to minimize what you've been through. I'm just trying to go based on my experience as a state's attorney, having tried these cases. Rarely do you have that situation happen. Sometimes where you usually see a probation before judgment is you see a probation before judgment in cases where somebody took the breath test and it comes in usually under 15, under 0.15 usually, and there was no damage to anybody else, no damage to property. There was not a kid in the car. It was they drank too much, and but for the grace of God, they didn't kill anybody. So having said that, we have the two kinds. There's the kinds where people blow and the kinds where people don't. And so the ones where people don't, again, it's about the same. If a police officer sees bad driving, that and nothing else, that might end up in a PBJ, particularly if they have taken steps prior to the case coming to a plea or to trial. That shows that they've gone to the victim impact panel that MAD runs, to do the things they need to do to go and get themselves assessed for alcohol addiction, things like that. So if they do those things that we want them to do anyway to make sure that they don't come back, that already happens.
But I'm saying that would end up potentially in a PBJ.
Yes, would end up in a PBJ.
And then those individuals would then have the interlock system.
They would have the interlock on it, yeah. For 6 months, considering 6 months if it would be their first time going through the system, which generally speaking, that's what this would be.
And if a person blew a 0.9,
sure,
would they still go through that? And there were no, and they decided they were going to go through that whole process.
Sure.
What's the likelihood that they could end up with something less than a PBJ?
Less than a PBJ is the case is dismissed.
Correct.
So I would say it is unusual to have that happen. It doesn't mean it hasn't happened. It just means it's unusual. I would say, yeah. So what's your question again?
I'm just trying to figure out, and I'm tossed with this one.
Well, okay. So let me go to the other part of this. After they are found to have blown a 0.09, they have a choice in our law to either get their license suspended or go on the interlock to avoid the suspension. They can apply to MVA to do that. So they will be on the interlock for some period of time. Courts usually do look and say, okay, well, you've been on the interlock from here, so we're going to start it from here and go from here to here. So that's part of the issue too. Okay. Delegate Tomlinson, and then we're going to vote on the. I'm sorry. Oh, I missed you. Sorry, Delegate Valentine. I saw it before.
Thank you, Mr. Chair, and I apologize if I didn't read all of this properly, but I just want to be clear that this Ignition Interlock program will be part of the judiciary, not the administrative like it used to be with like the MVA. I guess what I'm getting at is when you're talking about mandatory, is that as like a condition of getting probation before judgment that we're requiring? I'm trying to think if they don't agree to participate is where I'm getting at. That's what I'm looking at.
They don't get the choice not to participate. This would be a mandatory participation.
In order to obtain the probation before judgment?
They would get the probation before judgment, and as part of their probation, they would be required to participate in the program.
So if it was a conviction, it's not a mandatory?
It is already a mandatory if they get a conviction.
If they get a conviction.
Yes.
Okay.
That was Noah's Law in 2017.
Okay.
Largely. Delegate Tomlinson.
Thank you, Chairman. When this bill was when the interlock portion of the bill was originally presented, the House version, and then I don't believe we ever had the Senate version come to us. I believe it's stuck in rules, I think, right now. I'd had an amendment drafted to amend the bill, and I still would like to try to amend it. Unfortunately, it applies to Senate Bill 528 and not House Bill 505. Could this be held at all?
At this point, we are fighting the clock at this point, so we're trying to address the issues that are here. First of all, we're on the amendment right now, so let me deal with the amendment as it stands. All in favor of the amendment, please raise your hands. Is there anyone opposed to the amendment? All right, we're on the bill as amended. Delegate Tomlinson, what is it conceptually that you're trying to do again?
So, if with the addition of the new language as it relates to the ignition interlock system, and I believe I talked with a couple of you and maybe Holly. I think it seems like months ago now, but the idea was to not apply it to every person who receives a PBJ for DUI, but apply the interlock to folks who blow a .15 and over, or to folks who refuse at the scene, with the idea being that, I mean, it's already been established for years that, and the law already does treat the two different as blowing a .08 and over versus a .15 and refusing. Because I do think there is a separation between the two. And if the idea here, and from meeting with the interlock folks, I mean, the idea here is that they're trying to capture people who are going to be repeat offenders. I don't think if you're getting somebody who blows between a .08 necessarily and a .15, you're exactly capturing the people who are highly likely to be repeat offenders. I think you're getting people who, whatever, somebody after a PTA meeting, or somebody, who went to after work and had, I mean, depending on your size and weight, I mean, and gender, quite frankly, I mean, two drinks and you're blowing over.
So let me go to that point. So we already require under existing law that you participate in the interlock program if you are convicted of an A or a B. We already do that.
Yes.
So you're already there. And at the time that you're pulled over, you're given a whole DR-15 advice of rights. They read you the rights. The former officer could probably recite them from memory or not. And we're not. They've changed a little bit, but fine. Not making light of it, but there is already in current law effectively a choice that you get to make, whether you blow. To your point, the people who are over 15 are automatically in from the very start. The people under 15 but over .08 are not. However, they still get a choice of: do you want your license to be suspended, or do you want to go on the interlock from the very start? They already are having to do that. And the onerous nature of having your license suspended and not being able to drive at all usually results in people going and taking the interlock, because at least that way they would be able to get to work and be able to drive. So it is in a de facto way from the time they are pulled over, roughly, the pre-trial part of it would seem to encourage people to go to the interlock from the beginning already, and that's outside the scope of this bill. And then after conviction, they're already going on the interlock anyway. So that's why in discussions that maybe even we had, I don't think that would actually take us backwards on coverage for interlock, which is not something I believe that the committee wanted to do.
But what you're talking about is pre-trial.
Sure.
Versus, let's say you go to court and you do end up getting that PBJ.
Right. There are administrative sanctions that are already in place under MVA, because MVA can, and we can draft those sanctions under MVA because your license to drive is a privilege, and constitutionally we can do those administrative sanctions in the first place and not after. So that's why I don't think that the amendment that you're proposing, I don't think works, because that's already in existing law, and it is already part of that larger interlock structure that goes again, I think, to public safety at the end of the day for when people do those things. I know people need to get to caucus meetings, and so I'm sorry, but I'm going to have to very quickly. I'll go here and here, and then that's it.
But what I'm hearing you say is it's almost like time served.
To some degree, it could be. It depends on when the trial is. Yes.
Okay, that's. I just wanted to be clear on that. Thank you.
Delegate Tolles.
Thank you, Mr. Chair. I have two clarifying questions. So you're saying, is it 10 years or 15 years? So it's 15 years you can get your record expunged. If
Yes.
only if you have a PBJ, not if you.
Correct. This does not apply to convictions.
So I know from Prince George's County, there have been individuals who had DWIs who caused seriously bodily harm to individuals, and they received a PBJ. Mm-hmm. So they received a PBJ, and because they've had good attorneys, and so for that reason that I have serious issues with.
So the other part of this is it still goes through the PBJ structure, and the state's attorney can object to an expungement as part of the PBJ structure. So the state's attorney in one of those cases could stand up and say they got the benefit of the bargain, and I object to an expungement at the end of the day.
Okay.
There's a motion for a favorable and a second. Is there a second? And a second. All right. Further discussion. The vice chair. Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? No. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? Yes. Go ahead.
Just praying for a new mic system for next session. So just to explain why I'm a no vote, while I do support the interlock system being added, I think that's a great tool to have in the toolbox for helping people curb their, difficult to change behavior and save lives. I am completely morally opposed with any type of expungement because as we know and we've heard over the years, by the time someone is caught for their first DUI, they have driven dozens and dozens of times while they are intoxicated. And so it really doesn't matter to me if it's been 15 years because we actually have no clue how many times they could have killed somebody. So, and I'm very uncomfortable with the process that took place with that hearing on sine die and a basically gutted and amended bill. I don't think that we're doing our due diligence on this topic. This would have garnered a lot of opposition had we had a proper hearing for it with proper notification. So I will be a no.
Delegate Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes.
These new cars that drive themselves will remove the need and the prevalence of driving under the influence and all these deaths. Thank you, Mr. Chair.
Valentine? No. Conway? Yes. Kaufman? Yes.
I want to reiterate it because a witness was very animated this morning, that one of the reasons I'm comfortable voting for this is that state's attorneys can object. Thank you.
Williams? Yes. Motion is adopted. We have one amendment to Senate Bill 1 because what would it be like if we didn't have an amendment to Senate Bill 1? But this one, I believe Delegate Erican has looked at, and it clarifies the area of the law with regard to open and concealed, and it addresses the ability to allow a security guard, a correctional officer, a railroad officer, an employee of an armored car company to be able to open carry.
Along with all the exceptions under 4203, this is just putting it in 5307 for clarity purposes.
All right. Delegate Erican, briefly.
Yep, I just want to confirm on the record that it is my belief that the issues with 4203B are completely gone now. The Secretary cannot proffer any of his own policies, and the cards as they are going to be issued, should no longer have that 3-year penalty stipulation sort of printed on the
Believe that
back.
we have addressed that issue
Yep.
once
Okay.
and for all.
right.
All in favor of making this a committee amendment, say aye. Anybody opposed? All right. Thank you very much. We will be back. Thank you.